Blake Lively wants to begin gathering additional evidence in her lawsuit against Justin Baldoni, but his legal team is saying, not so fast. Your demands for material are way too much and are just a media ploy and maybe potentially aimed at intimidation. We're going to break down this new conflict between the two. Another battle is brewing in the ongoing conflict between Justin Baldoni and Blake Lively. This time it is about subpoenas. Now, we talked about the start of this last week. How Lively has gone on the offensive right now. As Lively, as we know, she has sued Justin Baldoni, her co-star, director of It Ends With Us, the film that they were in together. She also sued his production company, Wayfair executives, PR and crisis management experts that apparently worked with him, all alleging that Baldoni sexually harassed her and then launched a retaliatory smear campaign against her. And as Baldoni fired back in a lawsuit against her husband, Ryan Reynolds, also suing the New York Times. His argument is there was a coordinated effort to destroy his reputation with false allegations that he says were weaponized against him for Lively to essentially get control of the movie, take control of all aspects of production to get her way. And as all of this is going on, it was reported that Lively's legal team sent out a bunch of subpoenas to companies, one of the first steps in any kind of litigation. In fact, we talked about this last week, but her attorneys, Ezra Hudson and Michael Gottlieb, said in a statement that was published in the Hollywood Reporter, quote, Miss Lively has initiated discovery that will expose the people, tactics, and methods that have worked to destroy and bury her reputation and family over the past year. We will now receive all of the receipts that, unsurprisingly, are nowhere to be found on Mr. Friedman's website. And like Miss Lively, those receipts will have their day in court. Now, this is referring to Baldoni's attorney, Brian Friedman, and the website that was purportedly launched by him and Baldoni's team, featuring an amended complaint in this case, and also their version of a timeline of events in this story that featured never-before-seen text messages between Baldoni and Blake Lively, and Baldoni and Ryan Reynolds. And we've dedicated several episodes of Sidebar to breaking those down. If you want to check them out, they're up on our Law and Crime YouTube page. But just to further this before we get into the major update, a spokesperson for Blake Lively and Ryan Reynolds said to Deadline also, quote, we look forward to investigating more about Jed Wallace's entire business model and what else he was doing to distract from the very real sexual harassment and retaliation claims made by Miss Lively. We are delighted to be able to start discovery on it. Now, Jed Wallace is very interesting because he is somebody that Blake Lively initially named as a defendant in her first civil rights complaint that she filed with the California Civil Rights Division, but she didn't name him as a defendant as of yet in her official lawsuit. He ended up filing a lawsuit against her. His argument was, you first name me as a defendant, then you don't name me as a defendant. You defame me. You asserted false allegations against me. I had no part in this alleged smear campaign against you. She claims that he was one of the people who helped launch this digital army against her. The allegation was that there was a ton of negative stories and press and social media accounts that were all highlighted and amplified against her, and he was a part of it. So he has sued her for defamation. Actually, he's been seeking a declaratory judgment, meaning he wants the court to come forward and say, we looked at this. He is in no way a part of this alleged smear campaign against you. He wants a court to actually make that statement. I mentioned before, I think that's an uphill battle, but just to give you an idea, she wants to, look a little bit more into all aspects of this case. So we want to move on to what is happening right now. So the lawyers for Baldoni and co. filed a letter with the judge overseeing this case, Honorable Louis J. Lyman. And they say they want to make the court aware of a discovery issue, namely what they call, quote, overbroad subpoenas. Their letter reads, earlier this week, the Lively parties issued subpoenas to cellular providers, AT&T, Verizon, and T-Mobile, seeking, quote, all documents concerning ingoing and ongoing calls or text messages related to phone number, and then it's blocked out, belonging to each of the individual Wayfair parties, some of their employees, and various non-party individuals, including but not limited to call logs, text logs, data logs, and cell site location information. The subpoenas seek such information over a period of multiple years, in most cases spanning from December 1st, 2022 to the present. Now, What are they looking for? Keep that in mind. I'm going to get back to that in a little bit, but I will tell you, subpoenas in any case, but particularly this case, subpoenas for electronic records are so crucial. I mean, do we forget how all of this started when Lively filed her initial precursor complaint with the Civil Rights Department I mentioned in California? This was before she filed her official lawsuit. That complaint, and then the subsequent article that was published by the New York Times, featured bombshell text message conversations between Justin Baldoni and his PR and crisis management team, and also between them. And Lively claimed that these messages prove there was a plan to damage her reputation in the media, online, and in the public. And how did they get all of these text messages? Well, apparently they got these text messages, even though, by the way, that Baldoni claims these were cherry-picked and incomplete conversations. But they apparently got all of these text messages through subpoenas. Although, I will tell you, it wasn't entirely clear from where they got them, because according to Variety, though, her lawyers stated that they got the messages through a subpoena to Jones Works LLC. We'll talk about them in a little bit, but this was the company of a former PR representative for Justin Baldoni. She's engaged in her own separate litigation. I'll talk about that a little bit later. But Brian Friedman, who is one of Justin Baldoni's attorneys, he came out and said that none of his clients were actually subpoenaed, though. So did it all come from Jones Works LLC? I guess not entirely clear, but interesting. Anyway, you put that to the side. Once they got the messages, and look, they got the messages, then they launched this civil action. But let me be clear about something else. Those subpoenas were for the contents of those messages, right? We saw what those messages were. What's going on here is a little bit different. I want to continue on because in the letter it says, it is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history. This would include, of course, materials protected from disclosure by a laundry list of statutes and privileges, among them the attorney-client privilege, the spousal privilege, and the physician-patient privilege. Moreover, the information sought by the subpoenas is wildly disproportionate to the needs of the case and unnecessarily invades the privacy of untold numbers of third parties, including family, friends, business partners, and quite literally any other person with whom any of the targets have communicated with over a period of years. And then they cite Federal Rules of Civil Procedure 26, which limits discovery to, quote, any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Yes, they cite that language, but there are two other components of that rule that I want to list out too. Also, you have to consider, quote, the importance of the discovery in resolving the issues and whether the burden or expense of the proposed discovery outweighs its likely benefit. And it also says, by the way, information within this scope of discovery need not be admissible in evidence to be discoverable. In other words, you can maybe get access to material during this initial discovery phase that you may not ultimately be able to introduce at trial due to, issues like privilege or relevance, prejudicial issues. The judge will ultimately determine what can and can't come in leading up to the trial. But the key is not everything is subject to discovery. And if you're asking for something, what is the burden on the parties who have to respond here? So it has to be relevant, it has to be proportional, it has to be important, it can't be overly burdensome. The letter continues, quote, unfortunately, it appears that these subpoenas are more than anything else a media ploy, having been promptly leaked alongside a lengthy and combative statement by the Lively party's legal team. And they actually seemingly referenced the comments from Lively's attorneys, Mr. Gottlieb and Mr. Hudson, that I mentioned before. And honestly, even if that's true, kind of hard to blame the attorneys for making a public statement like that, given how public this battle has been and the numerous comments that Baldoni's attorney, Brian Friedman, has made in interviews into various media outlets. Although I will tell you right now, the court put on an admonition, a warning to both sides. Be careful about what you say in the media. Don't do anything that would prejudice this case in any way that might taint a future jury. But I will say, it honestly seems, though, that Baldoni's legal team doesn't really fault Lively's attorneys for making statements in the media because they write in the letter, the Wayfair parties are not remotely concerned about the Lively party's public statement, however hypocritical, and do not object to their use of third-party discovery tools. The Wayfair parties are using such tools themselves, albeit in a far narrower and legally permissible fashion. The letter continues, however, the Wayfair parties are deeply concerned that the Lively parties are intimidating third parties into providing information about our clients and various non-parties far beyond what is appropriate or even legal in civil litigation, including spousal communications, medical information, attorney-client communications, and real-time location information, among other things. The subpoenas constitute a flagrant abuse of the discovery process and, if allowed to stand, set a precedent that once their bluster dissipates, we are confident the Lively Party's counsel will not be prepared to accept when it comes to the scope of discovery into their own clients' private information and communications. In other words, meaning wait till we subpoena Blake Lively and Ryan Reynolds' information. After all, what Baldoni's team has presented so far has just been his communications with Blake Lively, his communications with Ryan Reynolds, and his communications with producers, executives, his publicist, crisis management specialist, the apparent intimacy coordinator. But what about the conversations between Blake Lively and, let's say, her publicist, or Ryan Reynolds and other people? Now, I will tell you, communications between Ryan Reynolds and Blake Lively, since they're married, that may be off limits due to the spousal privilege. Those private communications between husband and wife, they may possibly not be disclosed. We'll see which way that shakes out. But going back to the letter, and this part is important because usually a court will say, look, before you come to the court to complain about discovery issues, discovery disputes, can you try to figure this out between you two? Can you try to figure it out between the other side? Here's what the letter states. Quote, this afternoon we conferred in good faith via telephone with the Lively Party's counsel regarding the subpoenas, but were unable to resolve the dispute. This matter is highly time sensitive as certain of the cellular providers have already indicated they intend to comply with the subpoenas. The Wayfair parties therefore request your Honor's attention at the soonest possible opportunity. Well, now we have a response from Blake Lively's side, her legal team. And unsurprisingly, as we have seen with all aspects of this case so far, we have a completely different view and characterization of what is going on. Here's the opening paragraph of their letter. Quote, the Wayfair parties have failed to meaningfully meet and confer regarding their objections before seeking intervention from the court and completely misrepresent the subpoenas that have been served. The Wayfair parties' request to quash the subpoenas accordingly should be denied. The Wayfair parties have sued Miss Lively for a preposterous sum of $400 million for claiming, based on the Wayfair parties' own communications, that a retaliatory campaign existed, yet now appear to fear having third parties turn over the actual evidence that would document the who, what, when, where, and why of that campaign. On February 12, 2025, the Lively Reynolds parties issued notices of the subpoenas to the aforementioned carriers, seeking non-content records, that is, numerical logs, related to 15 specific individuals. Each individual is either a party to this action or the related matter of Jones v. Abel, or is an agent employee of a party who appears, based on evidence discovered in this case, to have a direct connection to the underlying issues. By the way, the Jones v. Abel case that was just mentioned there, that is a separate lawsuit going on. So Stephanie Jones, who owns, as I mentioned before, Jones Works LLC, she was the former publicist of Justin Baldoni. She ended up suing him. Her former employee, Jennifer Abel, who acted as Baldoni's PR agent, she's actually a defendant in the lawsuit filed by Blake Lively. Melissa Nathan, this is Baldoni's crisis management expert, again, another person being sued by Blake Lively, but she's also a defendant in the Jones action. But here, Jones claims that, look, I wasn't a part of this alleged smear campaign against Blake Lively, and these defendants, Baldoni, Abel, Nathan, they conspired behind my back to do this, and they ended up pointing the finger at me and attacking me. But anyway, give you a side note, that's that separate action there. Back to the subpoenas. So Lively is claiming that these subpoenas to these communication companies are about 15 people who are either parties in this lawsuit or They are agents and employees of a party. So let's say, I'm just using an example here, if Justin Baldoni had an assistant, perhaps his communications with that person should come up, or that assistant's communications with a third party should come up. The paragraph continues, the requests are tailored to the time during which evidence shows each individual may have been involved in acts giving rise to Miss Lively's claims. Such information is not only relevant, but essential to unearth the network of individuals involved in the alleged retaliation scheme against Miss Lively. And to add a little bit more to that, so later on, and this is emphasized a bit more, it says, quote, the requested records will provide objective evidence on when and how the defendants and witnesses learned about Miss Lively's harassment allegations, and whether, when, and with whom the Wayfarer parties coordinated efforts to discredit Miss Lively through the press and social media. The requests are also tailored to key individuals and relevant time periods, may resolve core factual disputes, and are proportional. For example, the requests associated with crisis communications individuals who appear to have started their work on behalf of Baldoni and Wayfarer in 2024 are limited in time to a matter of months. In other words, our subpoena requests are for relevant, specific, and important information in this case. And though they don't give, specific details about what they're looking for, now we kind of get a sense of what they might be looking for. And by the way, during the course of discovery, you don't know exactly what you're going to get. You have an idea of what you're looking for, but who knows what might come from it. Well, from there, Lively's counsel goes into the allegation that Baldoni and co. did not actually meet in good faith as they claim. Remember that telephone meeting? They write, quote, it is clear that the Wayfarer parties had their letter motion prepared before even meeting and conferring, and they intended to file it regardless of what happened during the meet and confer. On February 14th, 2025, at 4 p.m., counsel for the parties participated in a telephonic conference regarding the Wayfarer parties' objections that the subpoenas seek substantive communications, which they do not, are overbroad, and implicate third-party privacy issues. The Lively Reynolds parties repeatedly clarified that the subpoenas seek only non-content data, such as call logs, and that nothing in the subpoena could fairly be construed as seeking from third parties any substantive communications. Further, the Lively Reynolds parties requested legal authority to support the Wayfarer parties' position regarding their objections, including their standing to make such objections on behalf of third parties. The Lively Reynolds parties additionally offered a number of suggestions to narrow the scope of their requests, including supplementing the subpoenas to clarify the non-content nature of the requests, to narrow the applicable timeframes, and to limit or withdraw the request for cell site location. Counsel for the Wayfarer parties refused to entertain any proposal, instead demanding that the subpoenas be immediately withdrawn in their entirety. Okay, lot to digest there. In other words, they are arguing essentially, hey, Wayfarer, Baldoni, that whole side, you claim our subpoenas are too broad? Well, your requested relief, throwing these subpoenas out in their entirety, that is way too broad. And they also call out the Wayfarer parties for the fact that they're not seeking a protective order here. If it's such an issue, why didn't you seek a protective order? In other words, a protective order is an order that prevents certain information from being disclosed or being turned over, or dictates the terms on how certain material is turned over, accessed. It limits the scope of what can be produced during discovery and so forth. But again, you didn't ask for a protective order. The letter continues. The call ended at 4:31 p.m. Exactly 30 minutes later, at 5:01 p.m., counsel for the Lively Reynolds parties emailed opposing counsel, reiterating the request for legal authority to support the Wayfarer parties' position, and agreed, as officers of the court, not to access or review any produced materials until the parties completed the meet and confer process. And then it says, see a certain exhibit, Exhibit A. Counsel for the Wayfarer parties did not respond, instead filing their pre-drafted letter motion. At 6:33 p.m., the Wayfarer parties provided notice for the first time that they had already served objections to the subpoenas on the carriers, which of course obviated any risk that the carriers would produce documents in advance of the compliance date or over the holiday weekend, which fabricated risk was the entire justification for burdening the court with this premature letter request rather than continuing the meet and confer process. And then it also says, see Exhibit B. So real quick, those exhibits do seem to back that up, because I'll give you an example. In one exhibit, there is an email chain about setting up that meeting between the lawyers, and I'm just going to highlight one email in particular. So this email is from Kristen Bender from the firm that's representing Blake Lively, and this is to Kevin A. Fritz of the firm representing Baldoni, Wayfair, and the other parties. And it reads, quote, "Hi, Kevin. To reiterate our call just now, we asked you to provide legal authority to support your position with respect to the phone carrier subpoenas. You refused to do so and said you would provide authority to the court. We are again requesting that you provide such authority to us before filing anything with the court so that we may meaningfully meet and confer. We do not think that your demand that we immediately withdraw the subpoenas while the meet and confer process is ongoing is appropriate, nor do we anticipate that the just served carriers will produce the records early prior to the opportunity to review any legal authority for your position. However, to allow for the necessary time to consider any cases you have in support of the Wayfair party's position in the highly unlikely event that documents are produced in connection with the subpoenas in advance, we can agree as officers of the court not to access or review the materials until the parties' meet and confer process is completed. Best, Kristen." Again, they're basically saying, you keep telling the court that this is a timely emergency situation, we need to resolve it. These carriers are not going to turn over anything immediately after everything that's been going on, and we won't review anything until we have an honest meeting between us before we have to get the court involved. Now, going back to the letter from Blake Lively's attorney, it reads, "The court should also deny the Wayfair party's request because the subpoenas seek directly relevant non-content records that are proportional to the needs of the case and no legitimate privilege concerns exist." I already explained what they're thinking these records will show and produce, but then there's this, quote, "The Wayfair parties misrepresent both the nature and the scope of the subpoenas, inaccurately stating that they seek spousal communications, medical information, attorney-client communications, among other things that could infringe on privilege. The requests do not seek the content of any communication, only call, text, and data logs. The Lively Reynolds parties have not sought and do not seek here anything other than non-content records as permitted by law. The Wayfair parties have cited no authority from any court in any jurisdiction to suggest that such subpoenas would be improper." And that's the important point here. So that's different than text messages that were first obtained or seemingly obtained through subpoena at the start of this case, where you can see what each party was saying to each other. What they're arguing here is courts have held in the past that this type of information that we're looking for here specifically, namely identifying information or information proving something exists or proving a conversation happened, not the actual content or substance of these communications, this is not protected by attorney-client privilege or spousal privilege. It's not the content of the communications. Also, they argue, Baldoni and Wayfair, they haven't explained how any of that information that we're looking for implicates medical privacy issues. Is it just they're speculating? And then finally, Lively's counsel addresses one more point. Wayfair's argument that third parties' privacy concerns could be impacted by these subpoenas. But Lively's counsel says that doesn't really work here because Wayfair and the other parties, Baldoni, they don't have any authority to make that objection. That's up to the third parties to stand up and say so. They have no claim or interest in those communications. We call that in the law standing. Essentially, they have no standing to make that objection. They're not the ones being potentially harmed or affected by these subpoenas. That's the third parties or the non-parties in this case. And Lively's lawyers also argue if Baldoni and co. had legitimate concerns here, why not move quickly to put a protective order in place, what I mentioned before. The letter concludes, for these reasons, the Lively Reynolds parties respectfully request that the court deny the Wayfair party's motion and allow discovery to proceed. So, at the time of this recording, no answer yet from the court, but what will the court decide? Well, look, the court will probably not allow a subpoena as broad as was described by Justin Baldoni's side, if that's really what's going on here, a log of every phone call and text message from someone over, 2-3 years, but maybe try to narrow that. At the same time, perhaps the court will allow discovery of all of these 15 people if they are relevant and related to the case and litigation. There seems to be an explanation of what exactly Lively is looking for, so maybe somewhere in between.